All right, good morning, everybody. Welcome, and thank you for attending this morning's program on workplace investigations in today's world. My name is Marc Terry, and along with me is my colleague, Reid Wakefield. As everybody has unlikely experienced, that over the last year, the pandemic has created a number of challenges and opportunities for all organizations, and that probably is going to continue for a bit longer, although we're making progress. One of those opportunities, though, for us is to be able to do programs like this, where you all get to be in your offices, your homes, or wherever you are and participate. We are broadcasting live from the studios here at Mirick O'Connell. We normally have an annual employment law seminar about this time of year, but obviously with the restrictions that have been in place so far, we haven't been able to do that. So this program is one in a series that are trying to provide a similar service to you. So far, we've had great turnout, and if you have missed any of the programs in the past, you can access them on our website at mirickoconnell.com or on YouTube. I will let you know that today's program is being recorded, and that we will share the program with everybody who's registered by recording probably early next week. Before we get into today's topic, I do want to just give you a brief overview of our firm for those of you who aren't familiar with all that we do. We have over 60 attorneys and offices in Worcester, Westboro, and Boston. We're a full-service firm, meaning our services cover everything that your organization needs as well as your personal legal needs. Reid and I certainly would welcome the opportunity to provide you with any information about the areas of our firm and introduce you to colleagues if you have any other needs that we can help you with. So turning to today's program, we want to encourage you to use the chat feature to submit questions. Our plan is to go through our materials and leave time at the end to answer those questions. And so we probably won't be taking questions during the program just because of logistics of doing that. But like I said, we do encourage you to use the chat feature, and we'll take a look at that towards the end. So that's our plan for the day. With that, why don't we get into the material? And by way of introduction, we wanted to just talk a little bit about why workplace investigations are as relevant today as ever. And that's really, when we look at the world, what's going on around us, we've had certainly a couple of movements, and by calling them that, I don't mean to suggest that there's any invalidity to them at all, but there have been certainly a lot of community activities going on around the world that really make investigations important. So what we've seen certainly in sort of broad societal movements, we have the Me Too movement, we have Black Lives Matter, and underlying all of that is social justice. And so what we've come to see more, and the reason why we think focusing on investigations when they're necessary, et cetera, is really because people are expecting more. Employees are now expecting action. They're more likely to come forward with complaints. They're more likely to escalate them. And our view is, as I said, that people are going to expect employers to handle them properly and to give them voice. So our hope is that we are going to be able to provide you a program today that talks about when that needs to happen, when you need to do investigations, how you try to do some preventative measures around that, but also how, most importantly, to do an investigation and do it well. I want to introduce my colleague, Reid. Reid is new to the firm. He joined us a couple of years ago, but he comes from the MCAD, where he was commissioned counsel. And so I think he's going to be able to provide some really useful insights to everybody about how this connects to work that ends up at the MCAD, why discrimination complaints come about, and some of the things that are going to be important. So those kind of comments I think he intends to embed into his part of the presentation. And with that, why don't I turn the program over to Reid to talk about why we do investigations.
All right, thanks very much, Marc, and I appreciate everyone joining us today. We're looking forward to next year where we can all get together in person, but like everything else over the past year, we'll make do. So first off, why would you want to investigate something in the first place? And so there are a few reasons. First and foremost are the legal requirements that create obligations for you to investigate. And so the biggest kind of hot button issue is sexual harassment. This applies to any harassment claim based on any protected class, that there's an obligation on the part of the employer to investigate potential knowledge or a report of harassment and effectively remedy that, stop the harassment, and make sure it's not happening in the future. In fact, there are cases that go, through trial where there might be a kind of a minor finding of liability, and the fact that the employer didn't do an adequate investigation gets them dinged with large punitive damages awards. So it's important to keep in mind that there are independent legal requirements that you have to investigate certain claims. Another important legal tip is on the harassment front is, an employer might not be automatically liable for harassment by one employee against another employee who aren't supervisors. And so if, as soon as the employer becomes aware of that, if they jump in, do a thorough investigation and end any harassment that's going on, they can protect themselves from those legal claims. So that's a critical piece of it. And then in general, getting ahead of potential legal claims and protecting the business going forward from legal claims that might come up. Most of everyone here is kind of familiar with discrimination claims in general. And kind of as a reminder, there are really two different lenses to look at discrimination claims. One is an adverse action. If an employee is claiming that they were denied a promotion, denied a pay increase, didn't get the job, was terminated, et cetera, some action that the employer took. And that's something that, you may want to investigate to get to the bottom of it, to make sure there was, a legitimate reason for the decision or what have you. But then there's the harassment or hostile work environment piece. And it's important to remember that a lot of times you might hear of this in the context of sexual harassment or, inappropriate racial comments in the workplace. But it's important to remember that a hostile work environment can result based on any class that's protected under discrimination law. So it could be age-based harassment, comments about how someone's too old for the job, that kind of thing, sexual orientation, religion, any of the protected classes you should be aware of can give rise to a hostile work environment claim, and those should be something that you want to investigate to make sure you're protecting yourself. The other category is kind of the broad whistleblower component based on the type of industry you're in. This could be a variety of different things, and there could be several different laws that come into play that require some investigations here. OSHA safety concerns, if someone brings that up in the workplace, that should be investigated. There could be different financial regulations that apply. If people report fraud or financial misconduct, there could be an obligation to investigate. So those are important to keep in mind. And then at the end of the day, it can just be a good human resource practice to support your employees in the workplace and create a culture where employees can be productive, getting the job done and concentrating on those kind of things. So if issues come up, it's important to investigate them, try and get ahead of them and investigate and resolve those and prevent issues before they escalate. So we're even talking about potential legal claims. Next slide.
So that's a nice segue, Reid, into some of the things we just want to touch on up front, which is some preventative measures. Right. So most people are going to be familiar with the idea of having a policy to communicate expectations. And there are some policies that are required by law in this area. One in particular is the sexual harassment policy. Every employer is supposed to have a sexual harassment policy. But there are other policies that we recommend as a matter of best practice. And in particular, think about a protected class harassment policy. This is tying back to Reid's prior point. Now, there are types of hostile work environments that attach to age or disability. So it's not just sexual harassment that we worry about. And you can have adverse actions and you can have hostile work environments based on any of the protected classes. So while the sexual harassment policy is legally required by state law, we strongly recommend you have a very similar policy for all forms of protected class harassment. Other policies that might be appropriate or things that are wise to consider for best practices, electronic communications and social media policies that really often overlap into some of the same space, but just through a different medium. And so those kind of policies are things that really, at this day and age, most employers should have. Social media is, not everybody does that, but the other ones for sure. In terms of dissemination, sexual harassment policy, again, because it's legally required, has to be distributed upon hire and then annually thereafter. We recommend you use the same protocol even for these policies we recommend as a matter of best practice when not required. But circulating them, making sure people are aware of them is certainly a great way to demonstrate that as an employer, we do what we can to avoid having issues related to protected class harassment or discrimination. Training, certainly another significant thing that we can do. Certainly from a perspective of supervisors, training is really critical because every employer is responsible for the acts of its supervisors. So it's as important to focus on supervisors as anyone else, probably more so. Training for all staff is certainly preferred, but if I were to focus on one group, it certainly would be my supervisors. And so that ties into this last bullet point around understanding obligations. One of the things I've found in my years of practice at this point is that our middle managers tend to be the people that kind of create the most problems, not necessarily by their actions, but by their inactions. And it's a failure to understand sometimes what their obligations are with respect to reporting. You know, if somebody comes to a middle manager and says, I'm really concerned, I've heard somebody saying inappropriate jokes, and I'm using the term inappropriate vaguely here on purpose. But somebody comes forward and makes that complaint to a middle manager and says, but I don't want you to do anything about it. The middle manager responds saying, okay, well, if you want me to do something about it, let me know. That middle manager may have just opened up the floodgates to complaints down the road when somebody says, all right, now I can't take it. 6 months later, they make a complaint and say, I went to my middle manager and told them about it, and they did nothing. That puts the employer in a really bad spot. So helping middle managers understand that as supervisors, they have responsibilities and they need to be aware of those. Reid, is there any particular insight you want to offer, Can, from the MCAD perspective on this issue?
Yeah, I mean, I can't emphasize that last point enough. I mean, when I was at the MCAD and then, you know, in private practice as well, you see it come up time and time again. I mean, an employer can be strictly liable for, you know, actions of supervisors. And then if a supervisor knew about, you know, I'm going to get to kind of when to investigate, but if a supervisor knew of an issue, observed an issue, heard of an issue, and doesn't take action, doesn't, you know, put it up the ladder to get it addressed, that can create, you know, liability issues for employers. And so I think it's critical that supervisors, especially low-level supervisors, understand that they have an obligation to be aware of what's going on and report it. It really is a good practice to make sure those supervisors are aware of what their obligations are in that respect.
Next slide.
And so what are some of the triggers to initiate an investigation, right? So the obvious one is if someone comes to you and makes allegations of some kind, and this could be allegations of explicitly making direct allegations of a legal violation. It could be information that's a potential legal violation, but then you should be, you know, attuned to potential just policy violations or other misconduct that, you know, may not be jump right in your face as something that's might violate the law, but it's something that you should look into. And these can be formal or informal. You know, the obligation to investigate that I mentioned earlier, it does not have to be triggered by a formal report or a written report of any kind. It's based on a knew or should have known type standard, right? So if you as the employer, including those mid to low level supervisors, are should have known about an issue, you know, enough information came to them that they should have looked into it, that's when you need to actually take the next step and investigate and look into it. You can't just turn a blind eye to issues because they didn't come to you in some sort of particular format or in a direct way. And an important point too is it's the organization's decision whether to investigate a complaint, proceed with an investigation to find out more information. It's not up to the reporting party or the potential victim, you know, et cetera. So sometimes I hear about people, you know, employers who didn't perform an investigation because the employee told them, you know what, I don't want to make a formal complaint, you know, or employer says, you know, they came to me and they mentioned some inappropriate conduct, but they said they just wanted me to be aware of it. They didn't want to escalate it to a formal complaint. You know, none of that really matters when it comes to the employer protecting itself and fulfilling its obligations to you know, its legal obligations and its obligations to its employee. So it's important that when that information comes to you, that it's investigated. So those are kind of the triggers. And next slide. And we kind of included some little examples here of potential triggers, and we're kind of picking on Frank a little bit here, but some examples are, you know, someone making a passive comment, right? It's not a direct report. I'm sick of Frank asking about my sexual orientation. You know, if someone with the company, a supervisor, HR person hears about something like this, what does that really mean? There's an obligation to look into it, ask those next questions to evaluate what's really going on behind the scenes here. Likewise, another passive, are you aware of Frank making inappropriate comments, right? The vague, inappropriate comment that people might make. You have an obligation as the employer to look behind the curtain a little bit, find out what those comments are. The last thing you want to do is to hear that, disregard it, and then you find out what those inappropriate comments are for the first time in litigation. I had a matter recently where the employee reported that they went to a supervisor and said just this almost exact same question: are you aware of so-and-so making inappropriate comments? Doesn't end up being addressed. And then when we read the complaint that's filed at the MCID, that's several pages long of extremely graphic, extremely explicit sexual comments that this employee was making, we then found out what the inappropriate comments are. So it's important that you take these seriously and look into them a little bit more. Don't tell anyone. This touches on what I mentioned earlier. The employee tells you not to tell anyone, but there's still that obligation to look into it. And then Frank has been sending me text messages, and this is presumably outside of the workplace even, right? But an employee sending messages like this to another employee after hours, and Marc mentioned the social media policies and everything. This is something that's important for the workplace that needs to be investigated too. Just maybe it didn't happen on work time, happen outside the workplace. If there's a connection, it's something that you should really be aware of. And it's important to note that, in this example, Frank doesn't have to be an employee necessarily, but employers should be aware of issues that come up between, clients or vendors, any third party who has a nexus to the workplace. If a client is harassing an employee or vice versa, these are all workplace issues that should be addressed. And then, like I mentioned, I don't want to make a formal complaint. That's not really that important. It needs to be addressed. Again, threatening me on Facebook, if there's a relationship to the workplace, that's something that you need to be investigating. And then this is another thing that sometimes we see a vague comment: I don't feel safe around so-and-so. And that can mean a whole lot of different things. And the point is, as the employer, you want to know what that means. It could mean they're being threatened with violence. It could be they're being harassed, and racial comments are being made about them. It could literally mean that Frank is not a safe guy and he's not following OSHA standards, or whatever the case may be. It opens up the door for you to find out more examples about this. And I know when Marc and I were kicking around examples, I know he's seen this a lot, and he's got some examples I think he wanted to touch on as well.
I was going to offer an example just from the last couple of weeks that came in, and that we received it by email to the HR person, and the email basically described a series of things that you would think about and kind of think, man, it sounds a little bit like a personality conflict. Somebody is just kind of doing obnoxious things to another person. But in the email, the person who was complaining, or they didn't even want to call it a complaint, it kind of wasn't a formal complaint type of thing, but they were expressing their concerns. They shared in there that they had a medical condition that the employee was aware of. And while it didn't appear to be a claim of disability-based hostile work environment, my advice to the client was, let's see if we can figure that out, because we don't know. We had sort of two things embedded into one email. There wasn't an apparent connection between the two. But if the employee thought that it could be the case, or if upon our investigation we determined that it was the case, that was something that was going to be really important for us to figure out. And it was just a good example that struck me as we're preparing this material, to say, look, these things come in a lot of different shapes and sizes, and you have to do the digging to make sure we really understand what the concerns are. But also, even if the employee isn't sure what the trigger is or the foundation is, part of our investigation is designed to figure that out. And it may be that it turns out to be just a personality conflict, but it may also be something else. And we're always going to be better served by figuring out the answer to that question as best we can. Are we ready to go to the next slide, Reid?
Yep.
So the next slide. So now here we are. We've received a report of some kind. First steps, sort of self-evident, hopefully. You're going to review the allegation, figure out what's being complained of. Ideally, it's in writing. But remember, you can't require somebody to reduce it to writing, but you can ask them to do that if they haven't already. When you get it, first steps you want to do are evaluate what's there. What's the potential impact or claim? Are they being explicit about it being based on a protected class, sexual harassment, racial discrimination? Are they talking about some form of protected activity that they've engaged in, or that there was some action taken against them? I was disciplined because I'm Black, because of some protected activity. And take a look at your own policies to figure out what the rules are around this type of behavior. It's always important when you think about investigations, and I think we'll touch on this in a bit, that we're really focusing on policy violations. So it's always important when you receive a report to be thinking about, does this potentially implicate a policy? What does that policy say? Because that's going to help you frame out the questions you're trying to answer in your investigation. And certainly the last bullet point, and this is not intended as a plug for us, but think about whether or not you really know what you're looking at and whether or not you need advice of counsel before you start your investigation. Maybe you don't know whether there are issues there or whether the behavior is something. We get a lot of questions of, well, we just got this complaint of hostile work environment, but there's nothing in there to suggest that that term in a legal sense. It's not tied to a protected class. It's just a term a lot of people use because they feel like somebody's treating them poorly. Sometimes we get questions about, well, do I have to investigate that? And that's certainly something we work through with a lot of people. So we're always here to support you and provide legal advice as necessary. Can we go to the next slide, please? So one of the other initial steps you have to take when you first received a report is to figure out whether you need to take any interim measures. Most often, this is going to be something where you've got two people who work together. One's made a complaint against the other, whether it's a supervisor or a coworker. Our obligation is to make sure that whatever behavior is going on stops. It doesn't mean we have to know what's going on first. We just need to make sure that we take steps that are appropriate to prevent the behavior from continuing. So if we're talking about harassment by a supervisor against a subordinate employee, and the employee feels like they can't possibly work for that supervisor, we need to do something to separate those two. And the steps, the interim measures aren't going to be the same in all circumstances. And there are many cases where you actually don't have to do anything because the two people don't work together and they don't see each other. But it might be in that case even something as simple as telling them, all right, both of you stay away from each other. We're going to investigate this and neither of you should have any contact. So sometimes it's separating people. Sometimes it's placing the accused on leave. Even if you don't necessarily believe the complaint or you have serious questions about it, you need to make sure it doesn't continue. And one of the ways to do that is to take the alleged offender out of the workplace. So those are important things that have to be considered immediately upon receipt of the report, because if you learn about something and you take a couple of days to figure that out and the behavior continues, we're potentially liable for it once we learn about it. The other point to just kind of touch on here is timeliness. That's really timeliness of interim measures, which you've emphasized, but also your investigation. You shouldn't receive a complaint and say, I'll get to it in a couple of weeks. It may take a little while before you can really do an investigation for a lot of reasons, but we need to move things along quickly. There is no legal standard that says it must be completed in 10 days in almost all circumstances. There's some very unique circumstances for anybody from the school district who's online and worries about Title IX. There's sometimes some timelines we have to worry about there, but generally speaking, there's not a rigid timeline, but you do want to move things along. That's to protect the employee. That's also to protect the accused, to get the matter behind you. Closure on these things is important. Even if you ultimately figure out that there was wrongdoing, having the employee know what the outcome is rather than worrying about whether they're going to get fired is important to everybody moving forward. So there are a lot of reasons why we want to move quickly, even though there isn't a firm legal timeline on these things. Reid, I don't know if there's anything you want to add onto that, or whether we can move to the next slide.
Oh, next slides. And so you've got the report, and I think it's important now to kind of keeping in mind the remedial measures and the timeliness, kind of take a step back and decide what you're now going to do in the investigation, and not rush into it and plan ahead. And so the first thing you want to do is determine your goals. Like everything else in life, what is the reason that you're doing what you're doing, and what are you trying to accomplish? And kind of let that dictate your kind of plan of how you're going to attack it. And so, like I think Marc mentioned, you're looking at policy violations. What are the potential policy violations? What is that language? What's prohibited? What's not? And kind of outline how you're going to then determine whether those violations occurred, or it could be any other type of misconduct or issue that came up. It kind of depends on what you're looking at. And then what is the work product going to be? At the end of the investigation, are you putting together a particular report? Is it being directed to a certain person? Is it a more brief preliminary investigation? Is it a full formal investigation that's going to result in a report to a decision maker? And then to who's the decision maker? Maybe this is the time to consult with who that decision maker is going to be, to determine kind of what the goal is. The proper investigator, who's going to be the one to do the investigation, is going to depend a lot on the resources and the scope of your business. I'm sorry, I just had a technical glitch. That's the joy of doing these webinars. So it's going to depend on what the nature of your business is, organization, what your resources are, how large you are, what you have. And so, but some of the things to keep in mind is you want someone who's relatively impartial, right? You might not always have this flexibility, but it helps to have someone that's not as known to the parties they're going to be interviewing. It could be someone from a higher level that you bring in. It could be, an HR person. It could be, an HR person who handles a certain area of the organization. It's a different HR person comes in to do the investigation. Someone who's not, working, closely with the folks. You don't want it to be the decision maker, ideally, to perform the investigation. You want it to be someone else. And then who's going to be most effective for the particular investigation that you're doing? And again, this depends on resources and the nature of your organization as well. But you could make a decision: do you want a male investigator versus a female investigator, or one for each of the parties, depending on what the circumstances are? Does the person have experience doing investigations, or experience doing this type of investigation? Does the person have a good rapport with these particular individuals, or is there history there? All those kind of factors are important to evaluate. Whether you want to consider doing an external investigation and bringing in someone from the outside who's going to be, all those things that I just listed, someone who's going to be more neutral, someone who's going to be, have the experience to do investigations, whether it's something that you want to consider bringing an external person in for as part of it. Sometimes in certain circumstances that's kind of a little bit beyond the scope of our presentation today, but you might want to have an investigation done by counsel. And, if it's part of litigation or anticipating litigation, there could be reasons that you decide to have counsel do an investigation, as counsel. I mean, I'll do a lot of investigations, and I happen to be an employment lawyer, but I'm not doing the investigation as the attorney for the agency, but you may want to have counsel do an investigation. Multiple investigators, again, whether this is you break up components of the investigation, particular witnesses to different investigators, or you have two investigators do each interview, where one can witness be a witness to what was said. They can provide input to each other. Sometimes, particularly in serious, investigations into serious matters, having multiple investigators can be very helpful. Next slide. And so who are going to be the witnesses, right? Of course, the complaining party, the person who's making the report, the alleged offender, the person who's being accused. Other direct, indirect witnesses, people who, by direct, I mean people who may have witnessed the interaction. Indirect witnesses could be, the supervisor of the offender, the complainant, to add context to their job. You have to think about who would be the people with knowledge, who would, keeping in mind your goal, who is going to be able to add something to finding out what really happened here. Putting him in an order that helps guide you to finding out what you want to find out. Generally, we would recommend that the complaining party is the first person that you interview. And that way you get kind of the full story of what they're alleging. And then generally the alleged offender is the last person you interview. So you get to them, and by the time you get to them, you have all the different information from everyone else, all the documents, and you can better ask your questions and guide that interview with the accused at the end. Sometimes I'll see it where people, they get a report and the first thing they do is go right to the accused. Hey, did this happen? Without really, fleshing out the nature of the allegations, and that can cause issues. And then critically, you don't have to follow a script, or once you set the order, it doesn't have to be strict. You should be constantly reevaluating to do what makes sense and make those changes. You may, naturally, when you're talking to witnesses, you're going to come up with new witnesses and add witnesses, or you're going to decide, hey, you know what, I want to talk to that person first and get that information. You may remove witnesses, you may re-interview witnesses. So it's a fluid process that you should keep, going back to. Next slide. And then in addition to witnesses, it's important to not forget about documents. Documents can be extremely helpful, particularly in investigations. A lot of times it's a he said, she said. Witnesses can be unreliable, their recollection, and sometimes you have documents that can be really helpful about what happened. It could be, written communications, emails, text messages, Facebook posts, whatever the case may be, social media. If the issue that you're investigating has something to do with a personnel action, whether someone's claiming that they were denied a promotion, you want to look to those personnel documents and the background documents about that decision to make sure you can kind of evaluate it from that perspective. And then ask witnesses if they have any documents. When you're asking the witnesses, what documents might you have? Are there any documents that might be helpful? And then throughout the process, and then as always, keep reevaluating. So things might come up in the course of the investigation that you want to make sure you're kind of reevaluating. Next slide.
Okay, so now we've got our plan in place that we just summarized, and we're going to start doing some interviews. There's some things that we recommend that when you talk to a particular person or each person you speak to, that you do as sort of an introduction before you actually get into the substance of it. We've tried to outline some of those here, but what we try to tell people is this investigation is confidential, right? So we want people to know that we're going to handle it confidentially, but also we need to let them know that that has limits, right? And we most likely know in this group that there's always the possibility of some sort of claim being made, and if that's the case, that the investigation and what this person shares with us may be shared. It's also the case that something will be reviewed. Somebody, we'll talk about this later, but somebody's going to have to make a decision as to whether or not further action is taken. And so information will be shared, but we can't tell them it will be maintained as confidentially as possible. When we look at the sort of issue of privilege, some people think anytime they talk to their attorney, that communication is privileged. And so there are circumstances that we actually have a question about investigators being called as witnesses, and we'll address the question later. But certainly if an attorney is doing this, we need to be clear about what the purpose is and whether there is an attorney-client privilege or whether we just have somebody who has a JD doing an investigation, in which case it wouldn't be privileged. So we always want to be sort of forthright with people about that. And we want to tell people that although we maintain this confidentially, we don't want them talking to others about what they've shared or what they've been asked. Certainly if you're talking about a union setting or an accused, if they want to be able to talk to a union representative, confer with their counsel, those types of things. Those are permitted communications. We're not trying to interfere with their ability to be fairly represented during this process. We also want to make sure we tell people, and this can be, it can be a witness, it can be the accused, it can be anybody, but what we're telling them is don't retaliate against anybody because we're investigating something. Retaliation claims, there are a lot of them out there. And some of them even occur when there's actually no finding of wrongdoing, but people get angry and say, I can't believe you complained about me, I can't believe you did this, and they retaliate. They retaliate against either the person who complained about them or somebody who shared information or is perceived as sharing information. So we want to give a warning or directive, don't retaliate against anybody. I think it's also helpful to provide an explanation of the process. Something like, I've been asked to do an investigation into a particular allegation. Once I'm done with this, I'll submit a report to whoever the decision maker is. I will then expect that the decision maker will review it and, if appropriate, decide what actions have to follow. Giving a sense of process so that people don't think that the person who's doing the investigation is necessarily going to be the one to tell them what happened. It may be just an explanation to them of my role is here as an investigator to gather facts. And it is important, I think, in providing assurances, particularly to the person who is the alleged victim in the circumstances, that we're here to support them. We're here to find out what happened. And we want people to feel comfortable in sharing their stories, to know that we take these things seriously. Anything you can do to ease the tensions of the person who is coming forward to complain is I think, important. There are a couple other little things I want to mention while we're on this point, and that is there are some legal frameworks that people need to be aware of. There is a case called Johnny's Poultry. It's a National Labor Relations Board case from many years ago. And what it really talks about is there's an obligation to communicate the purpose to the witnesses, purpose of the interview, that no reprisals will be taken for participating or for providing information, but also that their participation is voluntary. And so while we make you aware of these obligations here for the folks who are have private sector unions, those are things you have to weigh. There are a lot of clients that have private sector unions that don't do this and just kind of run a risk. We want people to be informed about what those concerns are. So certainly, if you're an employer with the private sector and there's a union present, you're doing an investigation, you should really be conferring with somebody about these so-called Johnny Poultry's warnings. I will tell you that there was an effort in March to solicit information about whether to potentially overturn this case, but that the National Labor Relations Board still is being Republican controlled. I think when it transitions to Democrat, you won't likely see that pursued. And the other thing is for Weingarten. So a lot of people may be familiar with that, but what that means is that a person who is being interviewed, it's called an investigatory interview, and reasonably believes that the information that they provide might result in discipline. So this is really about the person who's accused. They have a right to have a union rep present. And we should at least be aware of that. There's no obligation to inform them of that right unless there's something unique in a collective bargaining agreement. But investigators should at least be aware of that. I think most people who have unions in the workplace probably are. Next slide, Katie. So when we talk about witness interviews in a framework, we're talking about individuals who are accused or witness things. We're talking about sort of the what are the allegations, observations, course of events, where, why, when. I like to break this slide down into sort of one simple thought, which is we really want our natural curiosity to drive what we do. Right? We're really just sitting here saying we want to figure out what happened. We want to figure out why it happened as well. But all of these things are the classic, who, what, why, where, why, when type questions that we're going to be asking. But I think to Reid's point earlier about sometimes going a little off your plan is a really important thing to remember, because you should go in with ideas of what you're going to ask or even scripted questions, but you don't want to stay so close to that you don't listen to the answers and that you don't take the opportunity to follow the conversation in a place that's going to give you better information. You don't want to say, okay, I asked that question, got an answer, moved on. You want to listen. You want to use your natural curiosity to keep asking questions until you feel like you fully understand what occurred in this circumstance. Next slide. So one of the things that I think is really important is to think about how you ask questions. And I'll give an example from something I was talking with a client about a couple of days ago. The concern that was expressed was that perhaps an employee had made a false statement about another employee by saying that they were intoxicated at work. They didn't say it to the person who was allegedly intoxicated. They said it to a friend or someone else. So there was a concern about whether they're just making things up, whether they're gossiping or what have you. That was the target, is to figure out whether this particular employee said that to another employee. But what I suggested in terms of a technique in interviewing this alleged wrongdoer is to ask broad questions first. Talk about what the relationship is between this person and the person they're claiming is drinking. Ask whether they have ever observed that, and slowly work your way towards the key question, which is, have you ever said to somebody else, to another employee, that this person was intoxicated? Because if you get the first answers to the question and learn that, oh no, I've never seen that person under the influence, and you have evidence in your pocket from somebody else that they were saying that, it really helps you hone in on, did they do the thing they're accused of doing, which is making up a false statement. So if you think about that as an illustration, begin open-ended with questions. You want to start in sort of a non-threatening conversational tone, as best you can. Every fact pattern is going to be a little different, but ask what's going on, ask for a complete account of events, then narrow in, explore the themes, like sort of, the example I said was sort of focused around whether there was alcohol use. And then at the end, get to your direct question. Well, did you ever say to this particular employee that in fact you had seen the other person under the influence at work? By moving in that direction, you do a couple of things. One, you give the employee an opportunity to kind of hang themselves if they're making things up or lying, but you also sort of keep them not knowing exactly what the target question is. And sometimes that's really an effective way to get information. Last two bullet points of the slide do harken back to something Reid said already, which is, ask if there are any documents, other witnesses. Always ask you, are there any documents that you think I should have that be related to the things I've asked you about? Are there any other witnesses you think I should talk to? Sometimes you will have something, well, I think you should talk to everybody so they understand that the person's a jerk. Just because somebody will say that doesn't mean you need to do those interviews. But you want to ask people, are there other people you think I should talk to? And I think as a follow-up, what do you think they're going to share with me? Okay, so with that, I think we can move to the next slide.
And so as far as witness interviews of the certain parties, certain things that you want to make sure you address in the interviews of the complaining party and the alleged offender is, one of the things that's good to ask of the complaining party is ask about what their desired outcome of their complaint and their investigation is. Ask them what they see would be a good resolution of the report. And you're not suggesting to them that that's the outcome that they're going to get, but having asking that question can help assure the complaining party that their voice is being heard, and then also help guide you to decide where you think this is headed or what's going to come of it. Another thing that sometimes people don't ask that is important to ask is, has the complaining party made previous reports about related things? Or they may be complaining about an incident that happened last week. Have there ever been prior incidents about this? Because a lot of the times, especially for the investigator, there could be a history that's not known. And so, if you're talking to the complaining party about one incident, they could say, hey, you know what, I've reported this before and nothing has been done. I've reported it, this and that. I've reported these different people, so you want to make sure you're asking those questions. And then when it comes to the accused party, it's important to advise them of what the allegations are and the scope of what you're investigating. And Marc touched on the right to union representation in those kind of environments. but sometimes an accused might ask, hey, can I bring an attorney, or can I bring another representative? And generally for private sector, non-unionized employers, the answer is no. They don't have rights to bring an attorney or have a coworker with them. That's something that can be dictated by the employer. And every situation is different. It could be the case that, you don't really mind if they bring a coworker or they have counsel present, as long as they're not interfering. That's the decision that you get to make. And then another thing too is, depending on the nature of the allegations, sometimes the accused might have allegations of their own. It could be a mutual thing between the complaining party and the alleged offender. And so don't overlook the fact that the alleged offender might just be very defensive, and you might not get into the fact that, this situation is bigger than you might know. It goes both ways. So ask those questions and be aware of those issues. Next slide. And then at the close of the interviews, it's always good to give, depending on how long the interview lasted and the nature of it, give those reminders to make sure they're keeping the substance of the conversation confidential. Remind them not to retaliate and that they won't be retaliated against. Make sure they know to follow up with the investigator if they have any additional information. Contact information. It's pretty common actually to, when you're interviewing a witness, they don't know what you're talking to them about in advance. You have a long conversation, and then the next day you get an email with, oh, by the way, I have all these documents and all this additional information. And so again, if you get that, it's important to review it, follow up, and then advise at least the complaining party and the alleged offender, what to expect going forward, and that they'll be informed of the outcome of the investigation when it's complete. Next slide. And then, like we've touched on a couple of times, constantly review and evaluate what you're doing. Go back and review, are there additional documents you might need or you've received? Are there additional witnesses? Anything that would add to Marc's point in finding out what happened. If you need additional information, you should evaluate that. Have new issues come up in the course of the investigation? Have there been additional allegations, accusations, and do those need follow-up? And then re-interviewing witnesses. It's not uncommon that you get to the end and then the alleged offender says a bunch of things and you need to go back and follow up with witnesses. Do what's necessary to complete the investigation and know what happened. Next slide.
So after you've done the investigation, one of the things that's really important is we preserve the evidence. If you have signed witness statements, which sometimes you do, sometimes you don't, you have physical evidence like photos, documents, other things. Sometimes these are hard drives too. You've got to take steps to preserve that, right? Because there is the potential for litigation, whether it's a grievance arbitration in a union setting, an MCAD case, or a federal district court case. Just one quick comment on signed witness statements. Some people feel like they always want to have a signed witness statement. Some people never do that. I think there are a couple of approaches there. One is that you do ask for a witness statement and you have the employee write it or the witness write it. Others are the person who did the interview kind of writes up a summary and asks the person to sign it. I think there are risks with both of those. If you give the witness an opportunity to write their own statement after they've talked with you, I will almost guarantee you something is going to change. It may not be material, but you then create a question as to what did the individual really think, and has it changed because somebody influenced them? So I'm not a big fan of asking individuals to write their own statements. On the other hand, if you write it up as a summary and you give it to the individual, they will also look at it and say, well, this is not what I meant, or this is not what I said. What I would suggest, Reid and I talked a little bit about this last week, is if you think that there's something really critical to the case that is like an excerpt from somebody's testimony that you're fairly confident that they're solid on, and you want to preserve that, then think about just having a limited statement that captures that information. Otherwise, you're more likely going to be better off keeping your notes, relying on your notes, and just using those to draft your report. Otherwise, witness statements become somewhat problematic. And keep in mind that if there is this threatened litigation, you will get what's called a litigation hold letter, which tells you to preserve everything, and that becomes really critical, or there are potential liabilities associated with not doing that. We should also be maintaining everything in an investigation file, which should remain confidential. Everything that's been collected as it relates to the investigation, including the investigator's notes, should be maintained in the investigation file. Next slide. There should also be some form of investigation report. If the issue is really confined and it becomes apparent after just talking to a couple of people that there is not much there, this can be a very short 1 paragraph, 2 paragraph summary of I received a complaint. This is what the complaint was. I talked to both people, determined this is what happened, and kind of end of story. But for anything of any substance, particularly things that relate to potential legal claims, we do recommend a more comprehensive investigation report. And here is a summary or a structure that we often use. Introduction simply says, this is what the allegation was as presented. The procedure and process outlines who was talked to, which witnesses did we talk to, what documents did we review, sometimes even with specific dates and times when that happened. Summarizing the evidence is not saying what happened as much as it is saying, this is what we were told. It doesn't have to be, and really shouldn't be, I asked this question, this is what answer I got, and you get that for every single witness. But it can be a summary of, I interviewed Reid, and Reid said that on such and such a date, he observed the following. And it can be just a narrative kind of translation like that. The findings of fact are really where you're reconciling the different things that you were told. Reid said this, Marc said that, and then the findings are, what do I think really happened as the investigator? And you have to make that judgment. He said, she said are often the challenge, and people don't really know what to do with that. We always have to say to you, well, what do you really think happened? Oh, I believe Reid. Marc always makes stuff up. That's okay. And that's your finding of fact, is that Reid was telling the truth and Marc was not. I think one of the most important points on this slide is its conclusions, and it's policy, not law. We do not want investigation reports that say, I conclude that Marc violated Chapter 151B because he discriminated against Reid based on race. Why? Because that will be Exhibit 1 before the MCAD, which says, even the employer agreed with us they broke the law, right? What we want is something that says, Reid engaged in the certain behaviors which violate our policy. That gives us, as an employer, an ability to make different arguments about policy violation. Which, remember, we go back to that at the beginning of this. There's a policy violation, but whether or not it was severe and pervasive, whether or not it really violated the law, that's a different argument for a different day, and that's not the purpose of our investigation. Conclusions will also address who we found credible and why. Recommendation is usually something that will say either I found that somebody did something wrong and I recommend that disciplinary action or retraining or assorted other reassignments should be considered, but they aren't necessarily specific. I recommend a termination because that is going to be for a decision maker to decide. And with that, I think we can move to the next slide.
And then so once the investigation is done, or at least the report is done, as the decision maker, you need to sit down and decide, what action steps are going to be taken. And so you obviously review the investigation report, and you want to make sure that it addressed all the concerns that you have as the decision maker. Are there additional concerns? Do you see the issues differently? Is there anything that you need to address? And you should feel free to return to the investigator and say, hey, well, we need to make sure we follow up on this, or I don't understand this. It's important that as the decision maker, you have all the information you need to go through the findings, accept, reject them, come up with, review the conclusions, and then, the recommendations, and decide how you want to proceed. Next slide. And then, so as far as action steps, it's important that you apply your policies as consistently as you can. When you're handing down disciplinary action or deciding not to hand down disciplinary action, and there could be corrective action that comes out of a investigation, and it could range the normal scope of corrective actions that we see all the time. Verbal warning, written warning, suspension, termination. There could be a demotion or a transfer, particularly if there's a supervisor who's having difficulties with a certain employee or being a supervisor at all. There could be restructuring there. And then there could be other measures to mitigate problems. Again, transferring someone who's not getting along in a certain group to a different group to avoid problems going forward. keeping employees separated, whether it's changing work schedules or that kind of thing, or physically separating them. There could be reorganization. We've seen, supervisors taken out of management roles, and so there's got to be a little bit of a reshuffling. So anything that, again, to go back to your obligations, to make sure you're effectively stopping any issue that's occurring and then preventing it from continuing in the future, make sure it's adequately remedied. Training is a big thing too. You may, as a result of the investigation, say, hey, there's really a need for training here to solve these problems going forward. It could be the individual, maybe a manager needs management training, sensitivity training, sexual harassment training. Could be the department. It could be, hey, we've got a failure of our supervisors. They're not reporting these issues and they need to be trained. Could be organization wide. So you should kind of have a open mind as to what solutions can be brought in to solve these problems going forward, both for the the accused employee as well as the organization. Next slide.
Okay, just a couple of last slides here to wrap up. So one of the things that's really important is the communication of the decision. You do have an obligation when you're dealing with sexual harassment complaints and others that are covered by discrimination law to let the person who complained know what the findings and conclusions were. It doesn't mean that you share with them the full report necessarily, and in most cases you won't. But you do need to tell them that we found your allegation to be sustained or not, meaning we believe you or we don't. Obviously, those conversations can be difficult if you don't believe the person, but sometimes it's as simple as explaining, what you perceived when we looked at these other facts was not supported. We understand what happened, but it's not the way you saw it. Whatever the outcome is, you do need to get back to the person who complained and the person who was accused, letting them know of the findings and conclusions of the investigation. You don't, however, tell the person who complained about what action, if any, you're going to take against the accused. Are they going to get fired? Are they getting a warning? You should, demote them. Those aren't the purview of the complaining party. That's between you and the person who did something wrong, and is a personnel matter that shouldn't be discussed. If there is corrective action necessary because we found some wrongdoing on the part of the accused, we would give them a redacted copy of the investigation report, taking out the names of other witnesses. We don't include the statements or exhibits, but we put that in the personnel file, presumably with a letter of discipline or corrective action saying you're given a written warning, you're being suspended for this, and attach the report to that. It certainly shouldn't be distributing the investigation report beyond anyone who really doesn't have a need to know, right? This really, at this point, should be in the hands of the investigator, and it should be in the hands of the person who's making a decision what to do. Importantly, this last bold point, these actions should be taken by the decision maker, not the investigator. Once the investigator has turned the report into the decision maker, and I don't know if we emphasized this earlier, but those really should be different people, if at all possible. It's not always possible in small organizations, but if at all possible, it should be a different person. And they should turn it over and say, here, Mr. or Mrs. Decision maker, I'm done. And they really shouldn't necessarily have a whole lot of influence or ongoing involvement with the issue. Next slide. So after the investigation, we've already done the follow-up. We've communicated to others, sort of what the outcome was, being just the accused and the complainant. But follow up. Make sure that anything that we said we're going to have to provide training, make sure it's done. It's also important to look back on the investigation and the actions and figure out, were our policies sufficient? Did somebody do something wrong that wasn't actually addressed by a policy? Do we need to modify our policy because we actually think what was done was wrong and it should have a policy? Do we need to provide training? This can be training to people who didn't understand what their obligations were. It can also be training for our investigators if we look at it and say, well, we kind of learned that we don't do this very well. Evaluate for best practices. And this is certainly stuff that we can always help with. And the last point, follow-up check-in, particularly with the person who's complained. You want to circle back with them. You want to let them know first, we're here to support you. If you need anything further from us, please let us know. If you are feeling like you're being retaliated against for any reason, please let us know immediately. But do some check-ins, a week afterwards, see how they're doing. 2 weeks after, see how they're doing. everything seems to go smoothly, you can stop that after a little while. But you want to keep an eye on this and not just assume that because you've done an investigation, you addressed the issue, that it's done. There are subtleties, and a lot of times we hear like, well, now the person won't even speak to me. And that may be sort of because they're being protective of themselves and they're worried about saying something or doing something that may be misperceived. But it's important that we stay engaged with the issue until we're really satisfied that everybody's kind of moved on from it. So I think that is our last point on here. We may have one more slide that says questions. So why don't we try to just take a couple. We're just at an hour and we'll take a few minutes to go through a couple of these. One of them, Reid, goes back to the point you were talking about in terms of who the investigator is. And the question is there a risk of having in-house counsel or regular outside defense counsel doing an investigation? Do you want to speak to that one?
Yeah, I don't have that on my screen. I'm sorry, can you repeat it for me again?
Sure. So these are in the chat, and the question is, isn't there a risk in having in-house counsel or regular outside defense counsel doing the investigation?
Yeah, I mean, I guess the risk would be mostly because that person doing the investigation, it may become a fact witness in your case. I mean, so I think that's the biggest factor that you need to look at. And again, this goes back to your planning stages on what you're trying to accomplish in the investigation. And so I can't think of any other reason that you couldn't have regular counsel and house counsel do your investigation, but that person could become a fact witness. And so if it becomes a legal claim later on, there could be ethical concerns with that attorney being, both the counsel for the employer and a fact witness. And so that can cause some complications that you probably want to avoid. But depending on the nature of the investigation, it's not something that you necessarily need to avoid.
Okay, I'll take the next one. So there's a question here about how much do you normally share with the accused party about the allegations or scope of the investigation? This is a really good one because I think my answer to that is it really depends. You certainly, through your investigation, need to ask all the questions so that the accused has a reasonable opportunity to understand what they're being asked about and answer those accusations. But I don't always start, in many cases, I don't start by saying, I'm here doing an investigation to find out whether you did X, Y, and Z. And that goes back to sort of the form of questioning, right? If we start broad and work towards more narrow questions, we don't necessarily want them to know where we're going. But if I haven't asked them questions specific enough so that they even have a clue as to what they're being accused of, then I haven't done my job and I haven't given them a fair opportunity to respond. So if you go back to the example I used before about a person spreading rumors, I need to get to that question of, did you say X to person, to the particular person we're talking about? Did you tell Reid that so-and-so is under the influence of alcohol at work? I need to ask them that question. But I don't always start by saying, here's what I'm looking at. Because I don't want them to know up front. Do you have any other thoughts on that, Reid?
Yeah, no, I think that's an excellent point. I mean, it's like I usually will share information in a trickle down effect, just like I'm asking open-ended questions to narrowing questions. And so at the beginning, it could be, we've received a report about some inappropriate language in the workplace. The person doesn't even necessarily know that they're the ones being accused, but over time, they've come to find out. And by the end, they know Jane Smith said this comment, right? So it's kind of a slow trickle. And then a related question I see in the chat is, must you ask identical questions of each individual interview? And the answer is absolutely not. And again, I think that you feel free to really tailor your questions to what you're trying to find out from that particular witness. And again, like Marc laid out and we just touched on, the best technique is an open-ended to narrowing. So you've got to let the conversation guide you. I would not treat it as an interrogation or I have to ask these certain questions. Naturally, you're going to be asking similar questions because you're talking about similar subjects, but you don't need to by any means follow a uniform script. Again, your goal is to find out the information, and however you can go about finding that information is what you should be doing.
I'll try to take the last two. One of the questions here is, what's the best approach when an investigation is initiated that is retaliatory with a predetermined end result? My best answer to that is we don't do that. That sounds like somebody who might have gotten burned somewhere along the way. Investigations shouldn't start with a predetermined end result. They should be designed to try to figure out what happened. And then the other question is, what about union employees retaliating against other union employees who participated in the investigation? Are there laws for employee-to-employee retaliation? There may be, but more often than not, this is a policy thing, right? So if we find out that people are retaliating against somebody for engaging in protected activity, which is participating in that investigation, in theory, that could be a protected activity that, depending on the allegations, could result in an MCAD claim. But more than anything else, it's really the employer's obligation to say, no, we don't tolerate that. And in theory, and we've had this come up, you have now a second investigation into whether someone is retaliating against somebody else for having participated in the investigation. And more often than not, that's the way it's going to be resolved, is potentially disciplining. And yes, it's more common in the union setting to see this, disciplining one union employee for having retaliated against another. And hopefully you've got some sort of policies in place that address that. Most sexual harassment policies, protected class harassment policies, going back to those, include something that says employees shall not retaliate against anybody for participating in an investigation. So I think that's the last question that we had. Want to thank everybody for participating today. We hope that this was helpful to you. Certainly, Reid and I are available. If anybody has follow-up questions, just give us a call or shoot us an email. We've got our email addresses up on the screen. And we will wish everybody a good day. Thank you.
Thanks so much.